let's talk about material facts. With the changes to legislation on the 23rd of March, we got a new definition of material fact. Now, this affects both sales agents and property managers. Now, traditionally, pre-March, the definition for salespeople was agents needed to disclose anything that would significantly affect the decision-making capacity of the purchaser. Talk about a broad definition of what needed to be done. But anyway, that's okay. And property management, they got, or at least residential property management, got a decent definition back in 2010 in the legislation in terms of what needed to be disclosed. The new definition in the Property and Stock Agents Act is quite prescriptive, which is great. It gives there's some real clarity around what does and doesn't need to be disclosed. So let's have a look at it. The first one is, in the last 5 years, if the property's been subject to flooding from a natural weather event or a bushfire. So yeah, that's really easy to identify, and certainly with the awful bushfires that our state have had at the beginning of this year, that certainly falls into that category. So in that 5-year period. If the property is subject to significant health or safety risks, so again needs to be disclosed if there's something significantly concerning about the property. If the property is listed on the loose fill asbestos insulation register. Now, this is the point that has made me want to talk about this issue today, because there's more, because it's now in the material fact definition, it's certainly become a topic of conversation. And you need to ask the question of your vendor, of your landlord, when you are listing the property for sale or lease. There are some of the companies that commercially sell agency agreements, such as ADL, EAC, REI. They have specific forms. It's the loose fill asbestos insulation questionnaire. So really, really straightforward on this point. So they can actually talk about, and you can get that signed off by your property owner as about their knowledge as to whether there's loose fill asbestos. If it's a property pre-1980, then it's a good question to ask. Now, you don't have to have that questionnaire filled in, but certainly it's sort of that extra compliance step. If the property's pre-1980 built, good idea to have that in there. Actually, a very good idea to have that in there, because it's proving that you've had the discussion, you've your vendor, your landlord has given you as much information as you possibly can. Certainly the vendor in these situations is very important from the sales perspective. So guys, find that loose fill asbestos questionnaire from whoever you're getting your agency agreements from. If they're not providing one of those, then maybe talk to them about getting one and adding it to their suite of forms that they offer to you. So that's one of the important parts of the new material fact definition. We've now got a time frame for the next point in terms of if the property was the scene of a crime or a murder or a manslaughter. We've got a time frame of 5 years now. We didn't have that previously for salespeople. Now, here does suicide fit into that? Is it a crime? Is it a murder? Is it a manslaughter? No, it's not even. It's not. It used to be a crime many years ago, but it's not now. Would you still disclose that? Yeah. Here's where perception comes in. Doesn't fit into your actual definition that we now have through the new legislation. Would you disclose it? Yeah, you probably would, because the perception of you as an agent here comes into your professionalism. So you would. The other new point, or one of the other new points in the definition, is that in the past 2 years, if the property has been used to manufacture, cultivate or supply prohibited drugs or plants. So that's 2 years. So it's not your normal 5 that we've got for anything else on timeframes. It's the 2-year definition. So new tenants, new purchasers, they need to know this information in terms of really the health and safety, if they've been actually making or manufacturing drugs in that property, and from a safety, so that's a health issue, safety issue in terms of, if they've been selling from that property, somebody new moving into the property would need to know that, they need to be on guard for who is coming to and from that property. So that's a really important one. And then there's the issue about combustible cladding. So, this is huge. Obviously in the strata sector. I mean, the insurance companies are now driving this from the point of view that they're actually asking the question to strata schemes when they do their annual insurance renewal, have you got a cladding clearance certificate? So even the old 1960s, 1970s red brick 2 up, 2 down style strata complexes are being asked the question. There's no cladding on those. But from an insurance perspective, the question's being asked. So again, ask the question of your owner. So they should know. If they don't know, if it's a strata building, then they need to go back and ask their strata manager. They need to talk about that, raise it at an owners corporation at a general meeting. So, that needs to be discussed. The other issue within that cladding issue is if there are any fire safety orders that come through that, if there's been any safety orders for rectifications in relation to cladding, if they've been issued, purchasers, tenants need to know this information. If there's any intention to apply for these or for the issue of it, if they've been, if there's something about, there's a building product rectification order. So there's a whole range of different things that you need to be asking on that level. So the cladding, it's the big new issue in terms of the compliance certificates that come with those. So if there's fire safety orders or there is a compliance certificate, great piece of information to have. And from a sales perspective, I guess a point of security or, something that buyers will want to hear when they're looking to purchase into a strata scheme. So in terms of material fact, the other form that's really useful is, again, some of the companies that sell agency agreements to you have specific material fact forms. Again, not legislatively required, but great documents in terms of protecting you as an agent. And, at the end of the day, the only person protecting you as an agent is you, the agent. So, ask as many questions as you can. It's not good enough anymore to go, don't want to hear. It is about finding out the information and disclosing that when and if necessary. So, guys, take material facts seriously. Make sure that you're dealing with it in terms of when you are listing a property, whether it is for sale or for lease, and have some of that documentation that's going to protect you as an agent as you proceed through whatever the property process is, whether it's sales or property management. So good luck with that one. That's we've had it now for a few months, so we should be talking about it. We should be making sure that it's happening, and working through that process.